Getting custody by consent is one way to establish legal custody in Louisiana. For this type of custody, both parents must be in agreement on the terms of the custody, including who the child will primarily live with and how often the parents will each be with the child. This is an easier approach for many families going through a separation or divorce, as it can be simpler and less stressful than court litigation. This video gives you an overview of the process. Step 1 is to have a discussion with your co-parent. First, parents should start with an open and honest discussion about their expectations, concerns, and objectives regarding their child's upbringing. It's crucial to prioritize the child's needs and well-being above all else. Step 2 is both parents working to develop and create a parenting plan. This plan should detail all aspects of the child's care, including living arrangements, education, health care, religious upbringing, and how to handle future disputes. It should be flexible enough to adapt to the child's changing needs. Step 3 is to draft a formal custody document to submit to the court. Once the parents have reached an agreement, they should draft the parenting plan into a formal custody document. The document should clearly outline the terms of custody, visitation schedules, and other relevant details. A legally binding agreement ensures that both parties adhere to the terms and provides a way to enforce the agreement if disputes arise. Step 4 is to file the agreement. Step 5 is to serve your court case to the other parent. When you file your petition, you must inform the other party about the case. If you and the child's other parent agree about custody and are willing to speak about the process, you can ask the other parent to waive service of process. If they will not waive service and they live in Louisiana, you must ask the court to have the sheriff serve them at home or work. Call the clerk of court of the parish where you plan to file your case and ask about the costs to file for custody. If you can pay the court fees, get your payment ready. If you cannot afford to pay your court fees in advance, then you can ask the court to proceed in forma pauperis. Make sure that you remember how you are carrying out service of process to the other parent to make sure they get a copy of the official court papers. Step 6 is to file your petition to the court. When you are ready to file your petition to the court, take your filing fees or IFP and your copy of the petition to the clerk of court's office where you want to file your case. The clerk of court will stamp a date and write a docket number on your case. The clerk of court's office will assign your case to a judge and a hearing officer, if there is one. The judge will then set hearing dates for your case, and the clerk of court will inform you of the hearing dates. Make sure to attend any court dates. Failure to do so can result in decisions being made in your absence, potentially to your disadvantage. During these hearings, the judge will review all submitted documents related to your custody case. The judge may ask you, and possibly the other parent, questions about your situation, your child, and your proposed custody and visitation plans. These questions help the judge assess the needs or concerns regarding the child. The judge will then make a recommendation or decision regarding custody and visitation. This can range from sole custody to one parent, joint custody, or specific visitation rights, aiming to serve the child's best interests. The recommendation will outline who has legal and/or physical custody of the child and the visitation schedule for the non-custodial parent. The judge's decision is formalized in a court order. The document details the custody arrangement, visitation schedule, and any other conditions the judge finds necessary for the child's welfare. Once issued, this order is legally binding. Both parents are required to comply with the terms of the custody and visitation order. This means adhering to the schedules and conditions set forth for custody and visitation, as well as any stipulations regarding decision-making for the child. Life circumstances can change, and the original custody order may no longer serve the best interest of the child. If this happens, either parent can request the court to modify the order. To do this, the requesting parent must file a petition and demonstrate that there has been a significant change in circumstances that warrants a revision of the custody arrangement. If one parent violates the custody or visitation order, the other parent can seek enforcement through the court. This might involve filing a motion with the court asking for the order to be enforced, which could lead to legal consequences for the violating parent, such as fines, changes to the custody arrangement, or, in severe cases, criminal charges. If you're unsure what to do, it might be a good idea to talk to a lawyer who knows about family law. A lawyer can explain how everything works and make sure your rights are looked after. They can review the proposed custody agreement and ensure the agreement is fair, respects both parents' legal rights, and primarily benefits the child. Thank you for taking the time to watch our video on getting child custody by consent in Louisiana. If you're looking for more detailed guidance and resources or need further assistance, we invite you to explore our website, louisianalawhelp.org. This information is designed to help you navigate the process of getting child custody, along with any other legal matters you may be facing.